before we start, for those of you who are not familiar with Wikborg Rein, we would like to give you a quick introduction to the firm. Wikborg Rein is a modern and dynamic law firm. We are an international team of over 220 lawyers with a wide range of nationalities and language abilities spread over 5 offices in Oslo, Bergen, London, Singapore, and Shanghai. We also have an alliance with a local law firm in Brazil. In recent years, we've been focusing on implementing and providing digital solutions to ensure effective cooperation and competitive pricing for our clients. As you can see from the slide on your screens, we advise on a wide range of specialist areas with a focus across all offices on shipping and offshore projects and disputes. So without further ado, I give the virtual floor to Helene.
Thank you very much, Ina. Hello again, everyone. Well, let's just jump straight into it, shall we? So for us, it's impossible to start this presentation without looking at what data is and how it has become one of the most important sources of information and income in the last century. Well, we think that Siemens CEO summed it up quite well, so we just put a little quote there. Unlike commodities, data is unlimited and it's a valuable asset in its own right. So obviously, the type and quality of data collected and transmitted have changed. And nowadays, all sorts of devices are becoming sources of data. So that can range from your smart fridge at home to vessels. And the issue is that this explosion of data being transmitted also means that all this information is also very vulnerable to leaks and data breaches. Well, we all know that digital transformation was already underway in our industry, but it is really being fast-tracked, especially now when we're facing the COVID-19 pandemic. However, we need to remember that the exchange and use of data brings with it significant risks alongside opportunities. But before looking at those risks, let's make a quick detour first. Well, you're all tech people here, so this is all very familiar to you, but just as a quick intro, I mean, you obviously all know that open innovation involves a flow of information into and out of the business, which can leave it more vulnerable, but also leave the actual ownership of IP and data uncertain. And our job here is to make sure that digital collaboration benefits to the business and not the opposite. So we as lawyers, we appreciate that in terms of digital collaboration, speed and flexibility are key. So obviously you don't want your legal team to waste time on final points of a project if the whole point of it is to access the market before competitors. However, this also means that the legal team needs a good understanding of the risks, while making sure that the collaboration is protected from the most obvious pitfalls, which I'm going to have a look at now. So now you should see on your screen that there are quite a few things to think about, even before starting the preliminary talks on a project. For instance, are you going to need a confidentiality or a non-disclosure agreement? Will you need a memorandum of understanding, or maybe an exclusivity agreement, or even a data sharing agreement? So that's a lot of things. And even at the start of this collaboration, it's very important for the parties to identify the IP that one or each party will contribute, and also determine if a third party's consent is required for the transfer and use of this IP. Well, we obviously don't have the time to go into each of these, but let's have a look at NDAs, because these are usually the most common first step. And then Ina will take you through the data sharing agreements. All right, so we're going to need a bit of context here. So before entering in a collaborative venture, there will be some discussions with the other side's team. So usually these discussions are quite casual, everything's still a bit up in the air, and there's usually no appetite to involve lawyers, and we honestly don't blame you. However, even at this stage, we think that it's wise to consider the implication of revealing to a third party confidential information. So we really think that it's really advisable to have contractual protection in place even at this stage. And that's when the NDA comes into play. So even if you might think that NDAs are usually really long and overcomplicated, this doesn't need to be that way. And in our view, usually the shorter ones are usually the better ones. However, what they need to do, those NDAs, they must impose obligations on one party, or usually more commonly, both parties, to preserve the confidentiality of any information or documents disclosed during the initial stages of collaboration. So we know there's a lot of templates of NDAs online, but they are usually not tailored to your business needs. And the needs of a very young startup are going to be very different from a well-established shipping firm. So, well, as you can see on the screen, there are a few key things to get right in an NDA. So I'm just going to go and jump straight to the definition and scope of confidential information. So first, the parties must agree what information should be categorized as confidential. So it's best to avoid being too specific and try to category broad. However, it shouldn't be too broad either. And because there's also no point including information already in the public domain, because that won't be deemed confidential in any event. So the wording is very important. Next, what is the information? So in the shipping industry, we don't really see much of secret formulas or things that are so obviously confidential. So usually what we see is that the parties are more likely to be discussing maybe a future bunkering arrangement, for instance, or they might, one company might be thinking to automate some of its processes and will need to send some internal data to the service provider. So that's another example. One last example can be customers' contact details, because these may become confidential information when you collate them and present them as part of the business profits. So that's another thing to think about. Then let's look at who will receive the information. So sometimes the disclosures will give information directly to one of the recipient's employees or advisors. So that can be even his banker or lawyers, who knows, rather than directly to the recipient, who is a party to the NDA. So what you need to make sure is that the information passed along will be protected by the NDA. So to do this, a definition of authorized recipients covering parties connected to the recipients but not party to the NDA will need to be included. So there's other things you can do with an NDA, and sometimes we see the parties limiting that NDA. So the disclosure may require the recipients to undertake to use the information for a specific purpose only. So we don't see many of these, but it's possible. And then one final thing to think about is the return and destructions of documents. So all the time actually, the disclosure will want to have the power under the NDA to require the recipient and authorized recipients to destroy or return its documents containing confidential information. So there are obviously practical limits on the extent to which electronic data can be destroyed, and companies are not really keen on wiping off their servers. Also bearing in mind that it's usually not even possible to completely delete chain of emails, for instance. So the solution for this is for the recipient to undertake that he or she will take all reasonable steps to expunge confidential information from its computers. So we see a lot of disclosures wanting the recipient to produce a declaration or a sworn statement from one of its director, confirming that he has returned or destroyed all confidential information. So that's a quite common clause. Well, I'm actually done on NDAs, and I will give the floor back to Ina, who will talk to you about the data sharing agreements.
Thank you, Helen. When the time comes in a project for the parties to share their data, it's important both from a contractual and a legal standpoint to ensure that a data sharing agreement is already in place. A data sharing agreement should clearly document what data is being shared and how that data can be used. And careful consideration should be given to what data protection regulations will be applicable to that data, depending on the type of data, the type of company, and the relevant jurisdictions. Data privacy and security regulations impose a number of requirements in connection with sharing of any personal data. So the EU's General Data Protection Regulation, more commonly known as the GDPR, for example, is one of the toughest privacy and security regulations in the world. Although it is an EU regulation, it imposes obligations onto organizations worldwide if they are targeting or collecting data related to individuals in the EU. And violations of this regulation can result in very harsh penalties. When negotiating a data sharing agreement, some of the key terms to be discussed and agreed are the following. The relevant data needs to be clearly defined, and the scope of use will need to be agreed together with any restrictions on such use. The parties should agree on how such data is to be shared and accessed. Data security measures will need to be addressed with a particular focus on specific regulatory requirements in the event that any personal data is being shared. And the agreement should also expressly address the parties' respective rights to existing intellectual property, any new intellectual property arising as a result of the collaboration, and any generated data. Other key terms to be addressed are confidentiality and, of course, termination. Following on from our discussion regarding NDAs and data sharing agreements, it's worth to briefly consider the electronic execution of commercial agreements generally, especially given the current global circumstances. Whether formal execution of an agreement is legally required will depend on the governing law and the type of agreement. Very generally speaking, the electronic execution of commercial agreements is usually acceptable. However, for example, powers of attorney will usually need to be formally documented and executed. So tailored legal advice should be sought regarding execution formalities of your specific agreement. Even when there is no legal requirement to have formal execution of an agreement, as you all know, it's common practice for the parties to record their agreement in a written and signed contract. So when signing such a contract with an electronic signatures, the parties should ensure that the type of signature used will be acceptable as evidence in the event of any subsequent disputes. Finally, we couldn't give a presentation about digital collaboration risks without mentioning cybersecurity. And as you know, ransomware cyber attacks occur regularly, including in the shipping industry. It is therefore imperative, both from a security and a regulatory standpoint, to use secure means to share information and data. There are many data sharing platforms available these days, and some more secure than others. I'm pleased to say that as part of our firm's digital innovation strategy, we offer clients the use of our secure data sharing platform, WR Collab. This platform allows for secure sharing of data between specified users, and also where required, we're able to offer bidders' rooms for specific project use. We hope you found that presentation helpful, and please don't hesitate to reach out to us should you have any questions, or if you'd like to discuss anything further, and if we can assist with your digital projects. Thank you for taking the time.
And thank you very much, Ina and Helen. And if there's one thing I've learned from maritime disputes and contracts, it's leave it to the pros. If you're not a mechanic, don't attempt to fix your car. If you're not an electrician, don't attempt to install strobe lights. And if you're not a maritime lawyer, try not to write your own NDAs. So anyway, thank you very much, guys. That's been a very, very valuable contribution. And we'll see you in the panel discussion shortly.
Thanks, Tim.
Thanks.